2022 Public Clemency Board meeting. The first half hour of the meeting will be open to the public from 10:30 until 11 a.m. and the second hour will be closed to the public from 11 to 12 p.m. pursuant to 1 DCMR 703.7 Section B. Before we begin, I just want to provide a reminder about a few housekeeping rules for the meeting. First, please make sure that your microphones are muted when you are not speaking. If you have any questions, please hold them. We will have a period for questions. However, feel free to take advantage of the chat function to send questions in, and we will happily address them during the question and answer portion of the meeting. Now I'd like to take attendance of board members present so we can make sure we have a quorum to proceed. I'll call the names of board members, so please let me know if you are here. Felisa Carter, Brian Ferguson, Indira Hennard, Emily Gunston.
Here.
Sonia Wael.
Here.
Katya Semyonova. Ilana Settenberg.
Here.
Great. So we have 5 members and we have reached a quorum, so we can proceed with the meeting. So our first order is old business. And I just want to welcome Dr. Indira Hennard, who's actually not on the call yet, but I believe will be joining today. Dr. Hennard has been appointed and duly sworn in. So she's the member with victim rights background. And when she comes on, I may indulge you and just welcome her again when she comes on the meeting. And as you know, we welcomed Mr. Ferguson to the board at our last meeting. We are very excited to have both Mr. Ferguson and Dr. Hennard on the Clemency board. We have a full complement. With that, I also want to take care of housekeeping matter for our, oh no, I'll do that later. So new business. So there's a brief update on the Clemency Justice establishment. The board's officially submitted all documentation needed to finally complete the Clemency board participation in the justice system. We are not in the stage of waiting. We are now in the stage of waiting to hear back from the CJCC about what that participation will look like. I'll now turn it over to the staff director who provided greater detail in the different processes that will need to be established for juvenile records and sealed records held by the Superior Court. Those records will not be able to be retrieved through justice. So with that, our staff director, Christina Sacco.
Good morning, everyone. Just wanted to provide you all an update on justice, but just a quick background. As you may recall, some of you are very familiar with justice because your organizations participate on the CJCC meetings, but we were allowed viewing authority via an MOA with the CJCC to have access to justice to retrieve some documents through the Superior Court, and those are granted with respect to adult records. With respect to juvenile records and records that are sealed, we were asked whether or not the Clemency Board would want access to those records, and our answer was yes, if it's necessary for the application, because not every application would have sealed records or juvenile records. So the Superior Court indicated that you cannot retrieve that information via justice. So they're building out a separate process for us. The chief judge is going to issue an administrative order granting us a different process for the juvenile records and sealed records. And what that would mean is obviously modifying the release to indicate that juvenile and sealed records would be retrieved in cases where they are relevant. Hence why I think we possibly should have a meeting to discuss what the form would look like, and we can certainly do that at our December 3rd meeting, and circulate a red line of the release concerning the Superior Court. But we're very grateful for the Superior Court for preemptively thinking about that and reaching back out to us. So the General Counsel's office did reach back out. We had a meeting on Wednesday. I did with them. And that's where they indicated this challenge for us with respect to juvenile and sealed records. But I just wanted to turn it over to the board for any advice and guidance on, um, when we can identify whether or not we should modify the application, um, asking specifically for juvenile records. I assume in the context of clemency, if we're looking at an applicant, we're looking at them holistically, that the board would want access to that information if it is there. Not, obviously, not all applications would have that information, but just wanted to defer to you all to see whether or not there's things I should consider that I'm not considering.
Christina, does it appear that the order will be comparable to what the agreement is with Justice, where the same limitations of viewing and timelines and all that sort of thing?
I'm not entirely sure what the order would look like, but I think the idea is to give us access. It's just that the access wouldn't be us retrieving that information. I think we'd actually have to send that release specifically with juvenile records or sealed records to the courts. And I believe the administrative order, they've had this sort of process established previously with other, I guess, bodies, to the point where for sealed records, I believe the applicant actually has to file a motion. And so for those of y'all who have done this before, please correct me if I'm misstating that, but the administrative order will forego that. There's a way to give us access without an applicant having to file a motion to unseal records. Yeah.
Christina, I'm sorry if you already said this. How does the federal clemency board or, how does DOJ deal with juvenile and sealed records and getting them and reviewing them?
That's a great question, Emily. I haven't gotten an answer to that yet, and I'm certainly going to circle back to that, given that this was just, brought to my attention on Wednesday. But I can certainly look into that. Ilana, I'm not entirely sure if you can speak to that from your point of perspective.
I don't think I have any insights into that, no. But I did have one question about kind of access to sealed records. Are we talking about like convictions that may have been sealed, or are we talking about sealed documents in cases? I just kind of wanted to clarify what we're talking about, because I think that there's a lot of variations and some might be more appropriate for broader distribution than others.
Right. From what I understand, I think it deals with sealed convictions.
Okay. Um, I'll just have to kind of think. So that would be handled via an administrative order?
Yeah, the chief judge deals with specifically with juvenile records and then with sealed records. They're going to inform me about what the process will look like. As of right now, on both our cases, before the board, we don't have that concern, but I think it would be important for us to build out that process should we have an application where those instances do arise.
Okay, and I defer to, Emily and others on juvenile records. But when it comes to sealed records, if you could just maybe kind of loop us into some of the languages, we're kind of thinking through that, and I could just think through a little bit more any implications. I can't think of any offhand, but I'll give it a little more thought.
Sure. Okay. Any other questions, concerns from the board? Okay, I will circle back with more information, but I just wanted to provide that tidbit of information that I learned to you all, so it doesn't come as a surprise when red lines and additional information come in via email with respect to the releases. But that would also require updating the application at a later time and updating the website and so forth. So I just want to let you all know about the layers of work that are required for this. But I think it's good that it's coming to us, because these are things, obviously, as we build out the process, we're not able to answer every single question, but as problems arise, it's nice that we can preemptively address them. Okay, turn it over to you, Patrick.
Great, thank you. So I just want to take a moment to, I see that Dr. Indira Hennard has joined us. Dr. Hennard, we wanted to welcome you to the Clemency Board and thank you for joining and for being willing to serve the residents of the District of Columbia in this capacity. We have been waiting for you for a long time and really happy to have someone managing the victims' rights aspects of our mission with us. So thank you for being here. I didn't know if you wanted to just take a moment to say hello and introduce yourself briefly.
Sure, absolutely. Thank you so much, Patrick. My name is Indira Hennard, and I'm the Executive Director of the DC Rape Crisis Center. My apologies that my camera is off. I'm trying to get my technology in order. It's such a joy to be with you all, and thank you all so much for having me, and I look forward to being in service.
Thank you so much. There is one housekeeping. I just want to make sure that you have access to your DCBC emails. Those are the emails that the staff uses to communicate with us on matters. And I think Moda has set that up for you. Have you been able to access those?
No, not yet. I'm actually having some technology trouble with that, so I'm working with them, and I'm hoping to have access by later on today.
Oh, that's fantastic. Yeah. And if Christina is also quite helpful in managing some of that stuff and figuring it out. So if you need a backup, we're available to help.
Great. Thank you so much.
Sure. Okay, so now back to our regularly scheduled agenda here. As board members are aware, the Clemency Board retrieves background information on each applicant through signed releases that applicants consent to. While processing the 2 applications before the board currently, the board staff director encountered a procedural snag with the CSOSA release, and because it lapses within 30 days. It's only for a 30-day release. The staff director recommends modifying the release by asking for CSOSA to extend that time period on the release. The reason for this recommendation is the staff director, while determining whether an application is complete or eligible, had the 30-day time period lapse. So then the staff director just administratively would be forced to send the release to CSOSA for processing again before making a determination of whether the application is complete and eligible. If the time on the release is extended, then it gives the staff director more time to properly process that application. So I just want to turn it over to Christina now to provide more details and answer any questions that we have and see where we go from here.
Thank you, Patrick. So for just to show you how this all relates, CSOSA is one of the agencies we retrieve information from, and CSOSA was the only agency that gave us 30 days to process a release on an applicant. With a particular application, we had been unable to reach the applicant to confirm whether or not this was even a DC code case. And so as the 30 days was nearing, I was forced to send out the releases before the time lapsed. And so that's where we're encountering that 30 days may not be enough to even determine whether or not the application is complete or eligible. So one of the most important things about eligibility is that there is a DC code case involved with the application that warrants, review for clemency purposes. And one of these applications, we think that may not have been the case, but we're waiting to confirm. But so if the board is opposed to it, here's another modification in addition to what the justice modifications are needed. I would recommend proposing that the CSOSA release be modified to extend the 30 days. I did preemptively mention it to CSOSA when I sent up the release and flagged it up to them, because when we were making these negotiations, I expressed that 30 days is not going to be enough, given that things are coming through the mail by the time we receive it and by the time we process it, 30 days would be a short time. And CSOSA expressed that we could revisit it when that time comes, but wanted to see if the board had any opposition to that, and if not, I could move forward with asking for an extended time period.
The individual who signs it would be also signing for this extended time period, right?
That's correct. Yes. So
Okay.
the signature.
Yes, then we wouldn't oppose that at all. I do think that you don't really need CSOSA to figure out whether somebody has a DC code case. that it would be just the court, because not every case, for instance, a misdemeanor case is probably not going to go through CSOSA at all. And it's possible even that a felony case where a pre-sentence report is waived will not go through CSOSA as well. So it could just go through the court. But that's an aside, but we don't object.
Great, thank you. And Katya, I'm so glad you raised that. That's exactly why I would recommend the extension, because in order to even determine it is a DC case, typically the goal would be once it's determined to be eligible and complete, then we would send out the releases. So we'd move forward with obtaining the background information. But in this case, I had to do the reverse because the time limit was lapsing. And so I'm actually glad that you mentioned that, because then we would, I think that would be a recommended modification as well if we're unable on the face of an application to determine if it is a DC case, which body would be the body we rely on to determine it is a DC code case.
Any other comments or questions about this? Okay, Christine, this doesn't require a vote, right? You just proceed.
Okay, if there are no objections, I'm happy to proceed. Thank you.
Okay, great. Okay, so that's the end of our new business in the open meeting. And so now we have an opportunity for public comments, and I see that there are members of the public present. Professor Moyd, I don't know if you want to add any comments.
I don't have any specific comments. The one question that I would have had, you answered, and that was just to get a feel for the applications that you guys are seeing coming in. And it sounds like I heard you say you have the board has 2 pending applications.
Yes, that's correct. There are 2 applications that we're reviewing currently. Christine, you want to say whatever more you can?
Sure, Professor Moyd. One is currently incomplete. We're waiting for additional information to complete it. And one, we're not entirely sure is a DC involved case. So that's what we'll discuss in our closed meeting and decide how to proceed.
Great, thank you. It's just good to know that applications are coming in and the word has gotten out and people are seeing this as a viable avenue. Thank you.
Well, actually, thank you, Professor Moyd. It's in no small measure because of the work that you and others in the community have done, and we appreciate that very much. So thank you for that. And if there are other places you think we should be going to talk to people, we welcome those ideas. Okay, so the last thing I want to do, if there are no other public comments, is just talk about a meeting schedule, which I believe that it's likely that the next meeting we would have would be to discuss an application. So that would be a closed meeting. We need to do that within 2 weeks. So I'm proposing that we would have a closed meeting of the board on Friday, November 18th at 11:30 a.m. I'm just wondering if anyone has a clear objection to that. We need a quorum of 5. And I think that I already have heard that works for at least 3 members. So if there are 2 other members, the closed meeting on the November 18th works for at 11:30. Appreciate that. Anybody who cannot attend?
That works for me.
Okay, that's 4.
Works for me. This is Felisa.
Hi, Felisa. Thank you. That's 5. Okay, so we can proceed. Brian, I hope you're able to join us that day too as well. See you on the call.
If I may interject for the November 18th meeting, Lisa kindly sent out their particular deadlines that we have to make to publish on the DC Register. I would recommend, depending on how our closed meeting goes today, that November 18th meeting possibly be sort of an emergency meeting, which won't require meeting the notice requirements, and we could provide the notice here on this call, and we'll put the notice on the website that we'll be having an emergency meeting because we won't be able to make a published deadline. But for the December 3rd meeting, we're able to publish it in the DC Register on time, so it's not a problem. So just wanted to put that out there for the board, and if anyone opposes, we can obviously push it back some more.
Right, and that's pretty much the chair's ability to schedule meetings, right?
That's correct. For emergency meetings, we just have to make sure we provide notice publicly in our meetings like this, in our public meeting, that it would be an emergency meeting to continue review of applications. And we would also publish it on the website, but it just would not be on the DC Register. That's the only issue.
Okay, so would like to go ahead with that, with the emergency then. Okay, and then the next open meeting, which may be like today, part open, and then a second closed meeting, depending on what business we have before us, would be, I'm proposing that it would be on Friday, December 2nd at 10:30 a.m. And if there's, I have, I believe, 3 members who are already able to participate in that. So if we have at least 2 more, so if you haven't already opined on that, can you tell me whether you're able to come on Friday, December 2nd, 10:30?
I have a conflict at that time.
Okay.
This is Felisa. I think I can make it, I think.
Okay. Thank you. Dr. Hennard, would it make a difference for you if we went a half hour earlier or later?
Later would make a difference, yes. I mean,
So-
later, meaning later I could do.
Like 11 o'clock, 11 a.m.?
Yep, that would be perfect.
Okay. Can others do 11 a.m. on Friday, December 2nd?
This is Emily. I can.
Yes, Brianna.
Works for me.
Yes,
Yes,
Felisa.
Katya.
Okay, that's it. So we'll go with that. We have enough then. So Friday, December 2nd at 11 a.m. Okay, great. So at this point, we're gonna, I'll take a motion to adjourn the meeting, and then we're gonna go into our closed meeting session, which is closed to the public. And Christina, we do need to go off this and onto the other link that was sent to board members.
That's correct, yes. So hopefully everyone on the call has the link to the closed meeting. If you don't, feel free to give me a call on my cell, and I'm happy to facilitate you getting logged on.
Okay, great. Thank you very much. Is there a motion to adjourn?
So moved.
Second?
Second.
All those in favor?
Aye.
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 All right, we're adjourned. Thank you, everybody. Appreciate your work.